Thank you, Chairman. In 2024, USPTO issued guidance on patent eligibility to help examiners and stakeholders evaluate whether AI-related inventions are eligible. Late last month, Director John Squires issued an opinion signaling even stronger support for AI-related inventions, clearing the Section 101 threshold. Mr. Kapos, let me start with you. I'd be interested in your thoughts on what AI-related inventions you believe should be eligible for a patent, what AI-related inventions you think should not be eligible. Is there a risk that allowing every AI-related invention to be patented could stifle innovation, and how do we ensure that the Patent Office strikes the right balance?
Well, thank you, Senator Schiff, for the question. So first of all, I would tell you that I applaud the recent changes made to the USPTO's eligibility guidelines by Director Squires, and I think also Deputy Director Coke Morgan Stewart before Director Squires got into his job. I think that they lend additional clarity and expansiveness to eligibility for AI-related inventions. I would echo some of the examples that you gave earlier, Senator Schiff, in terms of where the limit should be. Mathematical algorithms, mathematical formulas equals MC squared, pi, things like that, not eligible. They never were. They wouldn't be under PIRA. They shouldn't be, even if implemented or somehow related to AI. But practical applications of them, use in advancing computer technology, broadly stated, absolutely should be eligible. And the much more suited tests of sections 102, novelty, 103, obviousness, and 112, written description, are the tests that always did and should be returned to their role of doing the heavy lifting to determine what gets patented and what doesn't.
Well, thank you. Let me turn, if I can, to the diagnostic test issue. Ms. Cohen, you made a compelling argument regarding the lack of patentability and therefore the lack of investment. I'd be curious whether any of you want to share a counter argument. What is the case to be made for the lack of patentability? Is this just the court's getting it wrong? Is there a different balance that should be struck? What are the trade-offs here?
Happy to start with that, Senator Schiff, and it's a great question. So look, we all care about ourselves and our loved ones getting access to medical diagnostics. That is super important, and we all care about those diagnostics being appropriately priced, and we're all upset when they're not appropriately priced. So I think, broad agreement that pricing in diagnostics needs to be reasonable and fair. But pricing is a very different issue from patent eligibility. Patent eligibility is about whether the diagnostic exists in the first place, whether the cure is there to be priced at some price. Once the cure is there, once the patent system has done its job and broad eligibility has incented research and development and moving that through the FDA clinical approval process to make a diagnostic or drug available, fine, we should have very tough discussions about pricing, but we need to put them in totally different categories because the diagnostic that doesn't exist because the incentives weren't there might as well be priced at infinity.
Anyone have a different view?
No, but I don't. I suspect on the next panel you'll find at least one witness who does. But Senator, one point I want to add to what Director Kapos just said is the bottom line is currently de facto under the court rulings, various court rulings, there are no patents on diagnostic techniques in the United States. And one has to ask, who made that decision? If the United States decides not to protect by patent such a huge area of, an important area of technology, it seems to me that that needs to be subject to debate in this body and decision in a democratic way in this body. That is why, in my view, it is so important for Congress to return to legislating here where it hasn't done any since 1793 to address issues just like this. My personal view, and all my testimony today is just my own personal capacity, is that diagnostics are critically important technology, and we want to incentivize innovation in that area and investment in that area to bring more and more such new techniques that cure patients, treat patients, and overall increase improve the human condition. That's my view. And for that, you need to have patent eligibility in that space. And again, that doesn't mean that you're going to grant patents to all of those applications. You still have to make sure that the application, the invention is new, non-obvious, precise enough, and so on. But at least from an eligibility point of view, I don't think Congress has ever said that the United States should exclude that area of technology.
Thank you, Chairman.